The instruction on the manslaughter involuntary reads as follows. To prove this charge, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Ayanna Stanley Jones. That is, that Ms. Jones died as a result of the gunshot wound. Second, in doing the act that caused Ms. Jones's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, the trier of fact must find each of the following things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another, when to a reasonable person it must have been apparent that the result was likely to be serious injury. The key word here in this instruction is gross negligence means willfully disregarding the results to others. Now, as I see this instruction, I'm not really clear whether the three elements that the trier of fact would have to find coincide with willfulness. I don't see that. So, and I also don't see that there is evidence in this case that supports, or evidence whether it supports or not support. I don't see the evidence that the defendant willfully disregarded the results to others. The entire trial has basically been about the carelessness of the defendant based on his skills. So, looking at the evidence in the light most favorable to the prosecution, there seems to be a conflict between one part of the instruction and another part of the instruction. There is no evidence in this court's opinion that supports willfully disregarding the results to others. But the three things that the trier of fact has to look at for gross negligence really are questions for a trier of fact. The trier of fact could decide if the defendant knew of the danger to another, that he knew that there was a situation that required him to take ordinary care to avoid injuring another. The trier of fact can decide that whether the defendant could have avoided injuring another by using ordinary care. And the trier of fact can decide if the defendant failed to use the ordinary care to prevent injuring another, when to a reasonable person it must have been apparent that the result was likely to be serious injury. So with this conflict, I'm going to, if I am going to err, I'm going to err on the side of the defense, and I'm going to grant the motion for dismissing count one.
Thank you, Judge.
Okay.
You know, people object to that, and people ask for a stay before we do closing arguments, so that I can talk to my supervisors upstairs about an emergency interlocutory appeal, because it's our position that the elements have been satisfied as the court indicated, and the legal definition is willfulness, and the jury has to decide the elements of the crime, and that's what the court instructs them. And the elements, as the court has said, are there. There's enough on this record to send this to the jury on the elements of involuntary manslaughter.
I think that the elements on A, B, and C are there. What is confusing is in the definition of gross negligence, it says that the act must be willful, and I haven't heard. I don't know if I've heard anything about a willfulness to perform the act or failure to perform the act. I've heard carelessness.
We've heard lots of testimony about the standard of ordinary care, what that standard of ordinary care is, the training, the equipment, all of that stuff that we've heard over and over again about what the standard of care is.
Right.
The definition of gross negligence means willfully disregarding the results to others. It's defining that as being more than just carelessness or recklessness, more than just ordinary negligence. If the court looks at the jury instruction that defines the differences between negligence, it talks about that.
Right, the degree of negligence.
Right, how gross negligence is a higher degree of negligence. It's not an intentional crime. We've never said that the court, that this is an intentional crime. Gross negligence is not an intentional crime. It is a crime that occurs when someone knows better and someone knows they're supposed to do something and they don't do it, or they have an act they're supposed to perform, and they don't do that act, or they fail to perform an act they're supposed to perform. And that's how the courts have defined gross negligence as a willful violation. But for the jury, they have to decide the three elements of the crime. They don't decide whether it's willful or not. They decide, is it gross negligence? And the way they do that is A, B, and C. And if they find A, B, and C, that means it's gross negligence. That means it's a willful violation. Because we all know the jury instructions say that you take everything as a whole, but you're also going to look at the elements of the crime. That's all I have to prove. So if the jury decides that I proved A, B, and C, they find gross negligence. That, by legal definition, is a willful violation of his obligation to act. That's how the courts have defined gross negligence. It's a bad jury instruction, but the elements,
right.
Yes,
that's
the elements
the
are clear. The elements are clear, and the court has said that we have satisfied the elements. Okay. And for that reason, it should go to the jury.
I'll grant you a stay because I don't think that it'll take us long to resolve this. I actually don't think that it'll take more than maybe a couple of hours to resolve it. So I'll do that for, what I'll do is grant a recess for about an hour until about 11:10, and I'll also look at it again.
Thank you.
Because you use the right term. It's a bad instruction.
It is. I agree with that.
And if it's a bad instruction, then we should consider that in whether we submit this to the jury or not also. Okay? All right, let's take about an hour, please.